Thomas Westcott's fourth webinar. My name is Patrick Tigwell. I'm a general practice partner in the Exeter and Tiverton offices of TW, and it's my honour to be your host with the most this afternoon. With me, in a virtual sense anyway, is our head of tax and a partner at our Barnstaple and Bideford offices, Mark Tibbert. Now, Mark heads up our kind of COVID-19 group at TW and is leading our response to the various government initiatives that have come out and coordinating our response to them. For a first with TW, I'm delighted actually to welcome Karen Bates, who is the head of employment law at Foot Anstey solicitors. I was reading on Karen's sort of biog that she leads a team of 45 lawyers. It sounds like herding cats to me, but that's her problem, not mine. But it's great to get her on the call, because a lot of the issues that we found with the JRS have an employment law sort of slant. So it's great that she's here to answer the questions. As always, we have our fourth musketeer, our head of marketing, Jamie Giles. I'd like to thank him as well. He's doing the behind the scenes work. And as I said last week, although he supports Arsenal, he's not a bad bloke really. So that's the intro's done. How's it going to work? It's about a 30 to 40 minute webinar. It's going to be like a 4-course meal. Apologies if you've had your lunch already, but the starter will be Mark giving us a general overview of what's changed since last week, including the bounce back loan, which will be especially useful for smaller businesses. The main course, of course, is the JRS, and Mark again will give his take on that from an accountant TW perspective. Then I'll pass over to Karen for her employment law perspective on that. The suite, or the dessert course, will be a run through of mainly what Karen thinks of how the return to work will happen and the issues that are possibly arising from that. And the coffee and mints will be the questions that you've asked either when you registered or by all means sort of submit a question now. You've got two buttons, hopefully, the Q&A button or the chat button. Do it on the Q&A if you can, and then we can see them coming through and answer them. Either the guys will answer them on the way through, or we'll answer them at the end. If you do find that the webinar's finished and you desperately wanted to ask a question, don't fear, you can still do so at events@thomaswestcott, or one word, .co.uk. And we do promise to attend to every question, either ourselves or, if you're a client at TW, the partner responsible for your affairs. So that's everything done on that for the time being. Without further ado, I'll pass over to Mark for his, firstly, for his update on what's happened in the last week. So Mark, over to you.
Okay. Thanks, Patrick. Well, it's been a slightly quieter week than some weeks we've had from the government, but there were a few sort of big announcements that came out. As Patrick just touched on, a new scheme, the bounce back loans, was announced and should go live on Monday. It's essentially a simplified version of the CBILS scheme aimed at small businesses looking to lend between 2,000 and 50,000, or a maximum of 25% of a business's turnover. How it differs slightly from the CBILS scheme is that it is 100% guaranteed by the government. The first 12 months, as with the CBILS, will be interest-free, but there will be an automatic 12-month repayment holiday as well. It's meant to be a simple online standard application form across the banks that have agreed to do it. So we wait and see, probably during the course of next week, and maybe in our next update, as to what the take-up is of that and how well it's working. Sort of linked alongside that was an announcement on Wednesday on the CBILS scheme, where 7 of the leading banks, and potentially more will follow, have relaxed their requirements as to what applicants will need to provide for loans. The main relaxation is those key 7 banks, which includes all the high street banks. You will no longer need to do detailed business plans or cash flow statements, which was causing a big problem for especially some of the smaller businesses looking to borrow smaller amounts. Hopefully that will see the application process on that increase. I have been seeing some positivity around CBILS and the granting of CBILS loans, which is always good. It was slow to get started, but does seem to be helping the money flow through. Turning then to the main part of today, it was the job retention scheme. We're sort of 10 days now, just over past its go live date. It's pleased to say that we're seeing a lot of businesses actually starting to get the money that they were applying for, and it's coming through without any real issues. As with anything, there's been a few teething issues, and a few points just to note on it would be one of the requirements when you submit the claim is to have a national insurance number. For certain employees, you just simply won't have a national insurance number, i.e. those under 16 who haven't been issued one yet. Or you may have made every effort to try and obtain someone's NI number, but they simply can't find it for whatever reason. In those instances, you can't apply online. You have to go through the JRS helpline number and submit your claim over the phone where you have less than 100 employees. We understand that is a relatively simple process to go through. It's just a time-consuming one in getting through, and then providing all the details over the phone to an individual to type in. That we understand, at least the portal should be updated to allow you to submit claims without the NI number. Just be a case of time. The other relaxation we've seen wasn't widely publicised, but when you look through the detailed guidance, initially it was that you could only claim effectively every 3 weeks. That requirement seems to have disappeared now. So if you're processing weekly payrolls, in theory you can make a claim through the JRS portal every week, and you are also allowed to claim in advance of running the payroll. So if you need the money to actually pay people, you can submit your claim and then run the payroll shortly afterwards, just bearing in mind that it's taking 6 to 7 days from submission for the payment to come through. They were the sort of the main changes that we've seen, practical points. If I leave it back to you, Patrick, and I'll sort of cover off some of the questions a little bit later.
Yeah. Thank you. You just mentioned there that the employer can claim in advance of the pay run being. I suppose the theory is then they have the money to pay the wages in the first place. Are you aware of any sort of time, sort of period that they can claim? So is it sort of literally, I mean, you mentioned it was shortly before, and I think that's what the guidance says, but could you do it? I know you get your money 6 working days after, don't you? But could you do it a day before or 2 days before? Or
the guidance note itself simply says if the payroll is imminent, but when you look at some of the examples, they do say that you can effectively, if you know you're going to pay, say on the 30th of the month, you could submit your claim on the 24th if you've already calculated the payroll, so that you get the money at the same time as you're paying employees.
Okay.
The key is to make sure that what you are claiming is calculated correctly, and that all the money you get does go to the employees.
Okay. Just a general query, actually, just diverting from the JRS for a sec, just while I remember. In your update, there was obviously nothing, and I've seen nothing on what's in it for company directors of close companies, you know, the small companies where they are a director and a shareholder. We've had a couple of questions on that, you know, that saying, oh, well, I'm a company director, what help can I get? Presumably they haven't they haven't released anything else. That seems to be an obvious gap in their kind of gut in the assistance out there.
No, the position in terms of support for directors remains the same. If you are on the payroll and you were, or you say you had a monthly pay slip coming out to you, you can be furloughed. Or if so long as you were processed on the 19-20 payroll by the 19th of March, you can still furlough yourself based on your 19-20 pay. But that will exclude any dividends. I am aware that pressure has been put on government to try and consider sort of director shareholders where they were predominantly paid through dividends. At the moment, we haven't really seen anything come back from government. It's a difficult area because how do they distinguish between director shareholders paid in that way and just normal investors receiving dividends? And the other issue, which I am aware is causing some issue, and a number of bodies are making representations to government, including local MPs, is when they extended the job retention scheme to the 19th of March, they brought in a requirement that said you had to have had an RTI submission for the employee you want to claim before the 19th of March, which becomes a very limiting factor for, say, directors who, for admin purposes, may have been simply paying themselves on an annual basis and did their submission at the end of March, as they normally would every year. In principle, therefore, they don't meet the requirement for furlough or for the furlough reclaim and can't therefore get anything back. It also arguably still excludes people that may have been taken on by an employer at the end of February, because it was maybe a few days only in February. They weren't paid on the payroll in February and were processed in March's payroll. Those individuals fall through the gap. So as I say, I'm aware that representations are being made to government to maybe relax the RTI requirement and simply go back to what it was originally, that the employee had to have been on the payroll at the 19th of March. But so far, nothing has changed on that.
Okay, thanks for that, Mark. Just one question, quite an interesting one. They're saying, well, how do HMRC know who's being, you could put on your claim for fictitious employees. Obviously, I'm aware you've got to keep, my understanding is you've got to keep the record for 5 years, haven't you, so that HMRC can come back on you potentially. But would you agree there's scope for misuse and potentially if you just...
There's potential scope for misuse, but it's like all tax systems at the moment. It's self-assessment. You're making the calculations yourself. If you get it wrong and you don't correct it in time, if you know you've got it wrong, HMRC will no doubt come down on you if they pick it up during a review. One of the checks that the Revenue are doing is, I understand is the way they're working it, is they're checking the national insurance numbers against the individual employee names. So if you're trying to make them up, they will be checking national insurance numbers.
Okay, that makes sense, yeah. Good, okay. Well, let's give you a rest and turn over to Karen now. Karen, if you can give us your take on the JRS and how it's working from an employment law perspective, and perhaps, I think you mentioned before your sort of top 5 things, or certainly some issues that you're seeing.
Sure, thank you. So yeah, I mean, it's undoubtedly a very helpful scheme, and we've seen lots of engagement with it from our clients and our contacts, but it is one of those things that obviously has been brought in under huge time pressure, so it doesn't necessarily match with the employment law processes and HR processes that we're all familiar with, and those haven't actually been amended. So it's trying to take standard employment law and make it fit for this situation. Also, the guidance has been updated so many times in terms of the technical things that you need to do in terms of a whole range of things. So I was just going to give a quick overview of where we're at the moment on the employment law side. So I suppose in terms of the sort of high level view, the point being that if you're going to furlough an employee and put them on only 80% of their pay, which obviously you can do, that would still technically be a breach of contract or an unlawful deduction from wages. So you do need to be agreeing that provision with them. We certainly have larger clients with many hundreds of employees who just didn't have the capacity to actually always reach agreement with employees, and did take some level of risk on that in terms of writing to them and saying that the situation is such that we need to put you on furlough. But there is that technical risk. But we're finding most employees are agreeing to it. They understand the situation that businesses are in, and they are agreeing to the furlough provisions. That agreement should be in writing. There was a small, tedious sort of employment law panic at a certain stage where, when the guidance was updated, it said it must be agreed by employer and employee in writing, which gave the impression that you needed to have written confirmation from the employee that they agreed. That has been watered down now, so we think that it will be sufficient to have on the personnel file the written confirmation, even if you haven't been able to get back from the employee their consent. But good practice would be to get consent from the employee. Since the scheme was extended for a further month into June, another query we've had a lot is, well, can we just leave it running? No, you do need to go back. If you told employees they were furloughed to the end of May, you do need to go back and seek their agreement to be furloughed for a further period, and ideally record that consent on file if you can. And as suggested earlier, keep all of that for 5 years. Other areas of concern was around annual leave. There was a real lack of clarity about what to do on annual leave, which was particularly difficult, seeing as we had the Easter bank holidays. That position is clearer now, so the safe position on that would be to you can allow employees to take annual leave during a period of furlough leave. You can require them to take annual leave by giving them notice. The notice should be twice the length of the leave you want them to take. So if you want them to take a week, you should be giving them 2 weeks notice of that. But you should pay that leave at their normal pay rate, 100%, but you will be able to claim up to the 80% or the 2,500 limit in respect of that period. There have been concerns raised that also could be open to abuse, that employers might put employees, ask them to take their annual leave and seek repayments through the retention scheme. But again, I think in many ways it's fortunate that those provisions are being kept broad, because I think the majority of businesses are using this in a very genuine way. So it is your choice, essentially, whether you think it will be beneficial for the business for people to be using some periods of leave so that they don't have lots of holiday to take when they get back, or whether you'd prefer them to take it when they get back and you want to leave them on the 80%. Just trying to think of the other areas that have come up. I think there is all the issue around what do we do if they are sick or furloughed. That was causing a lot of difficulty at a certain period, because there was a conflict, so that basically if the employee was sick and would be receiving SSP, they'd be in a far worse position than an employee who's furloughed. There is now, I think, you would be able to take the view of choosing so SSP should apply if they are off sick, but ultimately if you've got a furloughed employee who's unwell, because they are not required to attend work, technically you may not need to know that they are unwell as such, and you could continue to furlough them. So that provision has been cleared up a bit. Shielding employees, so employees that need to shield because they have an underlying ill health condition, or they're shielding with family members. If they are shielding in line with public health guidance, then you can furlough them as well. The big change was the fact that at the beginning the scheme was designed around avoiding redundancies, which remains, I think, still the underpinning principle. But you don't need to prove that these are employees that you would have otherwise made redundant. It's actually for the business to declare that you are impacted by the COVID situation. So being impacted may be because you have a high number of employees who are having to self-isolate, for example, or to shield. And that being the case, you could still use the scheme to cover some of the costs, which is really helpful. There are other points I can cover off later in relation to sort of redundancy consultation, but I think we'll do that in response to some of the questions we've received.
Okay. Just a couple of points to sort of pick up with you then. We had a question that an employer had an employee on long-term sick, I think about 6 months. Can you then suddenly just switch them to furlough, just so it benefits the employee and at no cost to the employer?
So you potentially could. It does seem to be possible. They mustn't still be in receipt of SSP. You could switch them over. I think that is going to be easier to do if you're using the furlough scheme more generally. I think if you were only going to use it for that employee and actually the business is not affected by the current situation, then that's not in line with the principles of the scheme. But you could approach them as an employee, particularly if they are in a group that if they weren't unwell and they were back at work, they would be in that furloughed group. You could effectively be saying to them, would they prefer to take a period of furlough leave rather than sick leave?
Okay. Also, can an employee, if they're on furlough now, can they refuse to come off furlough?
No, they can't. So furlough is purely at the discretion of the employer, whether you offer it and when you bring people back. So bringing them back from a period of furlough is absolutely a reasonable line management request. There's nothing in the guidance about how much notice you need to give, but obviously you know, it does depend on the reason for having agreed furlough. For a number of employees, you might have agreed to furlough because of the current school situation, and obviously that's still in place. So I think the only grey area is the fact that, you know, if they can't return to work because of, you know, their shielding or they have childcare issues, you'd need to think about whether it's reasonable to require them to return. But if you have furloughed them because you had a reduced requirement for them and that has now changed as you begin to reopen or any other factors, you can call them back. And you can of course rota furlough as well, so you might choose to call some employees back and send others on a period of furlough leave if that feels fairer.
Yeah, on the sort of question of fairness, if you've got two employees doing the same thing and they've both been furloughed, is there any comeback if you sort of retain, you know, you get one back and you leave the other on furlough?
Yeah, no, there isn't. There's no claim really that could be brought in relation to a failure to offer furlough because it's entirely discretionary. So it's not a right that an employee could seek. I guess the only claim that may arise from the employee who's left on furlough, if they would prefer to be back, would be if you had done that for some underlying reason that's discriminatory. So it's just being careful about how objective those considerations are.
Okay. We can come back to more specifics in a minute and questions as they're asked. But obviously we noted that the government this week is saying, well, next week we're going to publish guidance on, you know, their roadmap of how they see the reopening of the economy. As a regular attendee of CBI webinars, they've had a succession of kind of business leaders. Have we had Unilever, the chairman, the chap from Kingfisher that owns B&Q,
yeah,
et cetera, all giving out their view and what they've done. But for most of our clients, they're not an Airbus, you know. Can you say, firstly, what are the issues that a smaller employer might have in the coming out of the the lockdown phase? And secondly, in a post-COVID-19 world, if we ever get there, you know, what are the issues potentially there as well?
Yeah, so absolutely, I've been on those webinars as well, and they have been really useful. But they are such big employers, aren't they? And they've got a lot of resource really at their disposal to think about these things. I think for smaller employers, it still needs to be that careful health and safety risk assessment. You know, even if you've just got one employee, you still have the duties towards them in terms of health and safety. So there are those considerations. We're hoping the government is going to come up with guidance based on rather than, they were looking at sector-based guidance, but now it's looking more likely to be based on the working environment. So is it manufacturing, is it office-based, etc., and bring out guidance for that. It's very likely that will, of course, still, in the initial phases, still involve social distancing of 2 meters. So you would need to have a look at the office environment or whatever the working environment is and work out whether that is possible, you know, both between employees and then employees and any customers. If it isn't possible, then it is thinking about what are the solutions. You know, is that being able to obtain PPE of some sort? I think that's quite controversial because of the pressures on PPE. So it's thinking about whether that realistically is an option that the business should put in place, depending on how essential the services are that you offer. It is still going to have, I think, this big element of if the work can be done remotely, it should be. So there is that test of, clearly there are lots of occupations that can only be carried out in person. And so that being the case, it would be doing that risk assessment and trying to bring people back safely. However, if it's just a preference that you would like them back, but they can work remotely, it would be better in that initial phase for them to work remotely. I think there is a reputational piece as well for the business around things like pressures on public transport, the health and safety of employees. Certainly things like in-person meetings and so on, if any of those things that could be conducted remotely, better if they are, particularly in those initial stages. I think, we've all seen the concern that actually this has been such an effective public health campaign that people are really worried about coming back to work. So even if you make all the assessments and decide it is safe for your employees, will they potentially refuse? If they do refuse, you do need to be careful about, there are claims that they could bring if they believe you've put their health and safety at risk by forcing them back to work. So you need to be as sure as you can be that the health and safety risk assessments you've carried out are right and that it is a safe working environment. If it is, then you can direct that it is safe and they do need to return. If there's any doubt, though, there would be less risk of a claim if you're able to reach agreement with the employee about what their circumstances are. If they can't return because of childcare issues or other personal issues that mean that it's difficult for them to come to work, then, and if furlough has come to an end, then we're back at a place of having to find a solution to that, potentially annual leave, unpaid leave. If they're unavailable to provide services, that's quite a grey area and quite difficult. I think in the current climate, disciplinary action around sort of unauthorised absence is probably the last resort, but it is something that you could consider, particularly if you're having to provide an essential service and it's really key for those employees to come in and they're not really able to provide good reason why they can't do it.
Okay, sounds like you're saying really you'd need services of an employment solicitor perhaps to sort of give you the guidance, but I don't know where we could find one at this short moment.
Yeah, my team's available. There's lots of us. We're all available, but we are.
Yeah.
We're putting lots of information on the Foot Anstey website. We've got a COVID area, and actually we've got a health and safety team of health and safety lawyers, and they're keeping up to date with the HSE guidance and trying to put a more practical slant on that and putting information there. So do have a look there as well.
Cool. Thank you. Mark, just back to you. We've had a couple of queries. If you bring someone back from furlough and then bring them back and then refurlough them, do they have to wait 3 weeks to be able to claim?
Yeah, so the requirement for furlough, to be able to make a furlough claim, is that each period they're on furlough has to be a minimum of 3 weeks. So you could put someone on for an example I'm aware of one employer doing is they've got their admin staff on furlough for the first 3 weeks of the month. They're bringing them back for the last week of the month to help deal with invoicing, payroll matters, and then putting them back on furlough again for the next 3 weeks. So long as it's always for at least a 3 week period, you're fine.
Okay. And just sort of diverting slightly, we have had a question actually from the same person, I think, that obviously this isn't about the self-employed income support scheme. Will we be covering this in a separate sort of webinar? Well, we probably will at some point, won't we? But we can't sort of confirm that just yet. We will be having a webinar perhaps, I think next week, possibly Thursday, but yet to be decided. But just on that self-employment scheme, Mark, do you know how it interacts with universal credit? Obviously they'll be getting, the self-employed should be getting their payments in early June, I believe. Would that affect sort of credit calculations?
Our understanding is that any income that you do get in through the grant would be taken into account for universal credit. But since nobody can say definitively what you will get at this point in time, if you're getting universal credit at the moment, it shouldn't impact immediately. It will only impact once you actually start to be in receipt of anything through the self-employed income scheme.
Yeah, okay. Just a couple of things, I'm just picking up on messages as they arise. We've had, it's more messages actually than questions, but useful. An attendee has said, we submitted our payroll on the 20th of the month, received furlough payment on the 28th. So 2 days prior to payday. So obviously very slick, and obviously there's no cash flow implications. So that's good news. And one of my colleagues, mine and Mark colleagues, Ian Huggett, who's a tax partner, he was saying, well, by any, responding to the point about whether there's any potential for misuse, he's saying, well, by only allowing claims for people who've already been on an RTI return does give a good check for the validity of employees. So yeah, that's great. Thanks, Ian. And just turning back to you, Karen, we've had a question actually. So I'll just read out what it says. Apologies for not looking right at the camera here. We have an employee who was on furlough but is disappointed with the amount that they were paid due to this 2,500 cap. The cap was explicitly stated in their signed furlough agreement that they now want to return to work to receive normal pay. Can we refuse, keep them on furlough, as it's a discretionary scheme, and actually they did agree to enter into the scheme in the first place?
Well, it's discretionary in terms of the employer's choice to put people on, but you do need to get their agreement. If that employee has signed up to agree that to a specific date, I think you would be able to say to them, we're relying on that agreement to the date that you agreed it. But if there's any ambiguity in the time period that they agreed to furlough for, then you would ideally, you would need to be agreeing with them that they stay on leave. So if they don't consent to that, you need to look at what the options are. I mean, that does slightly bring us onto the matter potentially of redundancies. If you can't, well, there's two things. If you have layoff provisions, formal layoff provisions in your contract, most employers don't, but in some industries you will. If you have layoff provisions, then you can say to them, if you don't consent to furlough, we'll put you on layoff instead. Now, layoff is far less financially attractive, so they're probably going to agree they'd rather remain on furlough. But without layoff, you don't necessarily have the right to put them on furlough. So you could then have a conversation with them to say, if you're not going to be on furlough, we can't afford for you to return, we do need to start looking at redundancy. You would obviously need to be very careful around selection for that if there are others in the team that haven't been furloughed, but that is a reasonable conversation that you can have so that someone is aware of what the implications of them coming back are.
Okay, so it sounds like if you said originally in the furlough agreement, well, okay, we're going to furlough you for a month, they haven't really got a leg to stand on there. But if you then say, actually want to extend the terms or the length, and say, well, actually, no, we want to take it to the end of June now.
Yeah.
Then obviously you're in more of an issue with, you need them to re-agree to the extension, don't you?
That's right, yeah. So if they don't, you need to look at those levers, which might be layoff, which might be redundancy, or, very frank conversation without putting them under undue pressure, but to explain, if you really can't afford for them to return to the business, what the other options are. Okay.
You've mentioned redundancy. That's come up a couple of times on the questions I've got on my other screen. And although obviously I won't mention the individual questioners, I do note that British Airways are sort of making 12,000 redundancies. Obviously, we note that the furlough is only at present going up to the 30th of June. For the smaller businesses then, who are thinking, look, okay, it's fine for now, but I've got to think ahead. What are the issues if they're thinking about redundancy for some of their employees? What are the issues that they potentially have to think about now?
Sure. So in terms of redundancy, if it's 20 or more redundancies at one establishment, so in one place, you do need to then be looking at collective consultation. It's 30 days minimum collective consultation for up to 100 redundancies. There's very strict penalties if you don't comply with that. It's a criminal offence not to submit the form HR1, and it's 90 days pay per employee for breach. So it's really important just to put in all of your minds that 20 number. If you're going to be looking at 20, and redundancies has a very wide meaning, so that would include voluntary redundancies, settlement agreements, and potentially changes to terms and conditions. So just pop that in your minds, and if that is going to be an issue, it is about really taking some advice on that just to make sure you get it right. If you wanted to then therefore obviously put that in place for the end of the furlough scheme, you'd need to be getting all of that planning in place. They have confirmed yesterday, in fact, that you can do the consultation with employees while they're on furlough. So you could consult with them so that at the end of furlough, they are redundant. If it's a case of individual redundancies below 20, again, you can actually have those consultations while someone's on furlough if you know that realistically you're not going to need them back. You need to think about the fair procedure for that. So it's two things mainly. One, is there a reduced requirement for employees to do work of a particular kind? That's the redundancy definition. if there is, how do you select the employees fairly for redundancy? You know, if you have 10 of them who do the same job and you only need 5 to be redundant, you need to carry out that objective selection criteria. It's really important not to just choose those who agree to go on furlough. I've seen that sort of start to creep in, that people are saying, well, my furloughed employees aren't coming back. But of course, you won't have carried out probably a formal selection process for furlough, so that won't make the redundancy fair. So you do need to look at how would you select them for redundancy, and it's all the usual procedures. Once they are selected, though, you have that short consultation with them, perhaps a couple of meetings. Obviously, take advice if you're not sure how that should work. ACAS has got some really good guidance on that. When they are redundant, the redundancy pay isn't covered by the furlough scheme. Notice pay may be. It's a very complicated position. Basically, if they're only entitled to statutory notice, the way that that interacts with employment law means that it's probably likely that you will need to pay that at the full pay rate, and you may not be able to make a grant reclaim in relation to that period. There is there's some clarification being asked around that at the moment. But if their notice period is longer than statutory, for example, a month or 3 months, you could serve them with notice and say that you would like them to remain on furlough during that notice period, and you reclaim their wages in the usual way through your grant reclaim. So it's looking at what the notice period is really. But I think now is the time, sadly, yeah, it is to be planning. If particularly, I think it would be very disruptive to potentially bring people back from furlough for a short period of time and then make them redundant. However, we're all waiting to know whether the furlough scheme will be extended, or whether a more flexible scheme that will come in to allow for sort of a phased return for work, part furlough, part working, which would be hugely helpful for lots of people. So we do need to wait for that, but absolutely you can have those redundancy consultations now if you need to.
With furloughed staff, so okay, you might have, I mean, would it be acceptable to do it on Zoom or this
Yeah,
sort of thing?
it is. It's not ideal. And again, no employment law procedures have actually been amended to fit the current circumstance that we're in. But there is nothing that says that a meeting must be in person or face to face. So you would just replicate the usual procedures that you would carry out for redundancy as far as you can to do them remotely for health and safety reasons. Allowing them to be accompanied. So even if that's virtually, they can invite a trade union representative or work colleague to accompany them online. So I suppose what I would say is, if you haven't put in place processes for that kind of virtual conversation, that would be the thing you do need to do. You can't just write to them and say, well, we can't meet, so here it is. You know, something like a Zoom call. It feels odd, but it is going to be the best way to try to do it.
Okay, thanks for that, Karen. Just to sort of finishing up really, we did have a question on charities and if there's any kind of special rules and regs relating to them. I'll come to you in a minute, sort of, Mark, for a more general update on charities. But Karen, while I'm with you there, obviously they've got to be careful if they're in receipt of grant funding, presumably with their furlough claim. Is that right?
Exactly that, yes. So it's just being careful about this point, that if you are in receipt of public funding, the expectation is that the employer would not be using this scheme. So if you are in, you know, the most common scenario we're coming across is that mix of private and public funding, which does make it difficult, and you should still therefore be able to use the scheme. But just potentially consider taking advice if you do have a particular level of public funding and or it applies to the area in which you want to furlough, because you might find that your reclaim isn't successful.
Okay, thanks for that, Karen. And Mark, just finally then, with charities, okay, they potentially can or can't use the furlough scheme. What other help is available to them?
Well, in terms of charities, there's nothing specific as such for charities. It's the same schemes as are open to every other business, subject to where it is public money that's coming in. What I would say is our charity team are looking to do a similar webinar Q&A like this, either towards the end of next week or the following week. So it's just keep an eye out on our website for details of that, and they'll be looking to address anything specific that has come out around charities.
Thank you, Mark. Actually, just one final question just popped in. This might be one for you, Karen. It's a question as to whether it's possible to ask employees to, in quote, give up their holiday accruing over the period. I mean, my understanding is that you can you reduce their holiday, but not to below the the 28 days. Is that right?
So, exactly that. Yeah, you don't need me for that one then. You've got that one.
Well, I could be your 46th lawyer, couldn't I?
Yeah, but probably the solution there is, yes, exactly. You could take it back to the minimum, but obviously you've got to think about that point. You want them to engage and agree to furlough. So it might be, to be changing their holidays might be an issue. So, the best position might be to be designating them to take some of that holiday now and use it, because you can claim the 80%. So that's still pretty helpful.
Okay, we have had just another query. The holiday accrual during furlough for 0-hour contract employees. Now, is that more of a technical question that we'd be better off just attending to after this webinar?
No, it's fine. It's a good question. So again, that hasn't been explicitly covered in the guidance, which is frustrating. Our view is those 0 hours employees, because you are not engaging them to work, it's a bizarre system, isn't it, that you're able to actually furlough those employees. It's great for those workers. It's giving them some financial cover at the moment. Our view is that they wouldn't accrue holiday because they're not carrying out assignments or actual work at the moment. So, normally a 0 hours worker might work for a day and they'll accrue a percentage of time in respect of that day that they work, and that's how they accrue their holiday. So we would think they would be very unlikely to receive any holiday pay claims for individuals who are furloughed, because you're not covering a period for which they would have been working. You are just using their average pay from a prior period to give them some cover.
And just finally, this better be the last question, otherwise Jamie will nag me for banging on. But you mentioned, Karen, the 20 employee maximum for redundancy before you have to have a group consultation. If you've got a group of companies with sort of 20 in each, is that okay? Or is it 20 for each company? Or
So it's about establishment. So it's actually where they are, potentially it's where they're geographically based. So if you had different retail stores and less than 20 employees in those different stores in different parts of the UK, you may actually be able to say that it doesn't apply because of those different locations. But it is an area where I would suggest you just take advice to check. It's quite a complicated area, and it's just one where it'd be worth taking, half an hour of advice to make sure you get it right, so that you don't have a problem.
Okay, thanks very much for that then, Karen. And I will draw it to a close now. Now, I would like to thank, obviously, Mark and Karen for their input today. I think it's answered. We've had a lot of good feedback for you guys answering the questions that are obviously uppermost in people's minds. I would remind you that if you haven't submitted a question yet, you still can on using our events email address. So that's events@thomaswestcott.co.uk, and we will respond to every question. And if you don't feel that we've answered your question, you can just resubmit it again on the events email. As Mark said, we are planning to do a charities webinar at some point very soon, so look out for that. There should be one next Thursday as well, so just before the bank holiday weekend. And all that remains for me to do is to thank everybody who's attended today, the speakers and you guys for registering and attending. And have a great day, a great weekend, and stay safe. Thank you very much. Cheers.
Thanks.